outset, I think I probably owe some words of explanation about the title for the speech. That title, as Professor Rogers explained, is Bits, Bats, and Buts, Reflections on International Dispute Resolution. And the title itself takes a little bit of explanation before I get into the substance of the speech. BITs, as we all know, are bilateral investment treaties, so-called BITs, that provide for both substantive international protections for foreign investors against things like expropriation or denial of fair and equitable treatment. At the same time, and this is in some ways what they're best known for, BITs also provide a means of dispute resolution, a procedural mechanism, typically international arbitration, for resolving investment disputes that arise under their substantive protections. The second word in the title, BATS, actually doesn't exist. Unlike BITs, BATS are not an existing international instrument. BATS, which stands for bilateral arbitration treaties, are not a treaty that is yet in force, is yet in existence, but rather the thesis of this speech is that BATS, bilateral arbitration treaties, are treaties that ought to be negotiated and ought to come into force and be adopted between states. And the essential focus of most of my talk today will be about exactly what a BAT is, what a bilateral arbitration treaty would comprise. And then turning to the third of the three words in the title, Bits, Bats, and Buts, the buts part of the talk will concern all the reasons that a BAT, a bilateral arbitration treaty, ought to give one pause, all the reasons that perhaps, although the concept can be proposed, although perhaps the concept of a BAT can be explored, at the end of the day, we ought to take a pass on it. At the end of the day, we should decide that the obstacles in the face of BATs, the objections to the dispute resolution mechanism that a BAT would contemplate, are so formidable that the proposal ought not to be pursued. And my talk today is going to explore all three of those topics, Bits, Bats, and Buts. I'd like to say at the outset, though, also preliminarily, that the concept of a BAT, I think, is of interest, both as a proposal, which in a sense is the way that the talk is structured and pitched, but also as a means of reflection, also as a way of exploring what it is that international dispute resolution should accomplish, why different forms of dispute resolution have been adopted, and just thinking as students, as scholars, about international dispute resolution generally, regardless whether one is enthusiastic or antagonistic towards the concept of a BAT. And so with that introduction, I'd like to turn first to the topic of BITs, which in a sense provides the starting point for my discussion of BATs. As I mentioned at the outset, BITs, bilateral investment treaties, have developed an important, indeed an extremely important means of international dispute resolution. It's a means that has its critics, that generates some controversy, but nonetheless a means which warrants study. It warrants study in part because there are today a very substantial number of bilateral investment treaties in force around the world. At last count, there were some 2,800 or so BITs, many of which, as I've already mentioned, include within them a dispute resolution mechanism that I'm going to say a few more words about. As I already said, though, one of the central features of a BIT is not only procedural, but is also substantive. Most bilateral investment treaties include within them substantive protections for foreign investors, protections that investments that they make in a host state will not be subject to expropriation, will not be the subject of denials of fair and equitable treatment, and a host of other substantive protections. Those protections vary from one bilateral investment treaty to another. They're tailored depending on what the interests and policies of the respective contracting states, two states in the case of bilateral investment treaties, are. And they set forth a series of protections aimed at ensuring that foreign investments are accorded appropriate and fair international treatment. Now, the main reason that we're talking about bilateral investment treaties today is not those substantive protections, but it is instead the dispute resolution mechanisms that are contained in most bilateral investment treaties in most BITs. And those dispute resolution mechanisms essentially provide, on the part of a host state, a so-called standing offer to arbitrate, which foreign investors falling within the defined terms of the bilateral investment treaty are permitted to accept in the event that they believe that their substantive rights under the bilateral investment treaty have been violated. And so, putting it very briefly, and volumes have been written on the subject, most bilateral investment treaties provide foreign investors protected by the treaty with a right to arbitrate against the host state in the event that they believe that their rights, their substantive rights under the treaty, have been violated. And the interesting thing, and in many ways the strikingly innovative thing about this arbitral mechanism, is that it did not depend and does not depend on the existence of a prior agreement to arbitrate in an investment agreement or a commercial contract or some other sort of agreement between the foreign investor and the host state. Rather, the bilateral investment treaty itself, without the need for a prior contract, gives foreign investors the right to commence an arbitration against the host state. It is, in the words, this mechanism is, in the words of one well-known commentator, arbitration without privity, arbitration without the usual sort of commercial arbitration agreement that's included in a contract that provides the basis for most international arbitrations. And it's useful to reflect for a moment on that means of international dispute resolution. Obviously, there are a variety of different approaches that could have been taken to dispute resolution in bilateral investment treaties. One can imagine that the states party to such treaties could have established an international investment court. One could have imagined that states generally could establish an international investment court modeled, for example, on the International Court of Justice or some other international tribunal. They didn't do that. States also might have left resolution of investment disputes simply to the negotiation of individual arbitration agreements between foreign investors and host states, leaving it to the time after a dispute has arisen for a traditional arbitration agreement to be negotiated. But again, they didn't do that. And of course, states could have left the resolution of investment disputes to national courts, to the courts of the host state or to some other state. But once again, they didn't do that. And instead, what they did, as I've already outlined, is to provide in the bilateral investment treaty for a right on the part of the foreign investor, an automatic right to commence arbitration against the host state, typically pursuant to a prescribed set of institutional rules. In some cases, those were the IICL rules. If the contracting parties to the BIT were also parties to the IICL Convention. In other cases, they were a specified international arbitral institution, whether the ICC, the LCIA, or something else. And in some cases, bilateral investment treaties provide for arbitration pursuant to the UNCITRAL arbitration rules, an internationally acceptable and neutral set of procedural rules. But in each case, essentially the BIT fed arbitrations, the arbitrations that foreign investors were entitled to commence under the terms of the BIT, regardless whether there was a pre-existing agreement to arbitrate, into a particular set of arbitration rules, either institutional or UNCITRAL rules. And why is it that the states, to these 2,800 or so bilateral investment treaties, have chosen that means of dispute resolution? The reason is that it is the least bad of all the available means of international dispute resolution. Or put somewhat more positively, I don't want to overstate the case, but I do think there's a more positive spin than least bad. International arbitration was thought, and still is thought, to provide the most efficient, the most objective and fair, the most expert, and the most enforceable means of dispute resolution. And I'm going to go on and explore, in the context of BATs, bilateral arbitration treaties, all of those various perceived advantages of international arbitration. But it was because the arbitral process, the process of international arbitration, was thought to provide those advantages of efficiency, speed, less costly, and of objectivity and neutrality, and expertise, that international arbitration was chosen as the means to resolve disputes under bilateral investment treaties. Now, one of the interesting things about investment arbitration is that it has drawn in significant part on the experiences of international commercial arbitration. One way that it has done that is precisely what I've just described. Now, the basic form of dispute resolution in bilateral investment treaties borrows on the form of arbitration, on the dispute resolution mechanism used for international commercial arbitration. The UNCITRAL rules, the IICL rules were all designed principally for international commercial arbitration, but was borrowed for bilateral investment treaty arbitration. In the same way, a number of the procedures that are used in investment arbitration also are modeled, in some cases closely, in some cases less closely, on commercial arbitration. And one of the theses of my talk this afternoon is that this borrowing process can work in both directions. It's not just investment arbitration that can learn from commercial arbitration, but there are ways in which commercial arbitration can learn from investment arbitration. There are two different types of dispute resolution, but they have close relationships in some ways, and each certainly has things to learn from the other. And now, turning specifically to the second part of my talk, the BATS proposal, the bilateral arbitration treaty proposal, my thesis is that international commercial arbitration, international dispute resolution, can learn from this form of arbitration without privity, this form of constructed consent, if you will, that has been adopted in bilateral investment treaties, and can put that same principle to use in the commercial context, in the context of international business disputes. And to start with the ending, if you will, to start with the proposal, the essential concept of a BAT, a bilateral arbitration treaty, is that two states, say Singapore and Romania or Thailand, conclude a bilateral treaty, in some ways similar to a bilateral investment treaty, providing, however, that all commercial disputes between nationals of their respective states will, unless otherwise agreed by the parties to those disputes, be resolved finally and exclusively by international arbitration according to a prescribed set of rules. So the essential concept is, under a BAT, international commercial disputes would be subject to a new, not currently existing, default means of dispute resolution. And that default means would be international arbitration. Now, I'd like to outline right at the outset some of the parameters of this proposal, and then before spending too long describing it, turn to the third part of my talk, the buts, the possible objections to this concept of a bilateral arbitration treaty. But it's important to note at the outset that this treaty would be concerned with business disputes, international commercial disputes, and that those disputes indeed could be defined and limited by particular sets of contracting states in their BAT, just as contracting states bilateral investment treaties define the scope of the issues that are submitted to the arbitral tribunal, define the scope of the substantive protections. And so, most obviously, in principle, states would, under this proposal, only be addressing business and commercial disputes, would not be addressing, for example, domestic disputes, of course not addressing criminal disputes, not addressing employment or consumer or labor disputes, at least unless two contracting states wish for whatever reason to do that. This would be a dispute resolution mechanism focused very much on core commercial disputes between businesses, not between consumers or individuals, not involving a consumer or an individual, but disputes involving two merchants, if you will, two commercial businesses, as opposed to either individuals or persons in similar situations. Second important parameter of this proposal is that it is a default mechanism. It is a mechanism that would apply if, but only if, the parties to a particular commercial relationship had not otherwise agreed. And it would therefore leave parties entirely free, for example, to negotiate a forum selection clause, to negotiate, as not infrequently is the case, that all disputes arising out of their commercial contract would be resolved in a particular national court, either one of the two contracting states or some third state. Parties would also be entirely free to agree to a different form of arbitration, some specialized form of institutional arbitration, for example, or whatever form of dispute resolution that they thought most advantageous to their particular interests. They might, for example, agree to expert determination, for example, or to fast-track arbitration or baseball arbitration or something of the sort. Nothing in the bilateral arbitration treaty would alter the parties' freedom of contract, their autonomy to agree to a particular form of dispute resolution. Rather, the BAT would provide a default mechanism that would be applicable if, but only if, the parties had failed to use their contractual autonomy to select a particular form of dispute resolution. And finally, and this is quite important, the BAT would provide, as I mentioned, an exclusive and binding form of dispute resolution. Parties to commercial relationships that were nationals of the respective contracting states would, unless they had agreed otherwise, be bound to resolve their dispute in accordance with the arbitral mechanism set out in the BAT. The courts of the respective contracting states, in our example, Singapore and Romania, would be required by the treaty to refer the parties to arbitration in the event that they sought to litigate their disputes in national courts. The BAT would impose a binding obligation on both the contracting parties, the contracting states, and also their nationals enforced through the courts of the contracting states to resolve their disputes by arbitration under the BAT unless they had agreed otherwise. And of course, parties would also be free to agree in the future, after their dispute arose, to submit their dispute for resolution in a particular way. But the fundamental concept would be that the BAT, absent contrary agreement by both parties, would provide the exclusive forum for dispute resolution. And finally, and equally important, the arbitral awards rendered by the arbitral tribunals under the terms of the BAT would be final, binding, and enforceable. The courts of both contracting states would be obliged to give effect to the award, either pursuant to standards such as those of the New York Convention or standards defined in the particular bilateral arbitration treaty. And this mechanism, this concept of arbitration without a traditional arbitration agreement, would be adopted in a BAT, and in this sense I'm turning now in a sense to the buts, but before I do that explicitly, let me finish, if I can, the reasons why states might adopt this bilateral arbitration treaty mechanism. States would adopt this mechanism for the same reason that they've adopted the New York Convention, to which some 150 or so states are party. They would adopt the bilateral arbitration treaty mechanism for the same reason that they have included international arbitration in their bilateral investment treaties, and they would adopt it for much the same reason that parties include arbitration agreements in their commercial contracts in many cases. And those reasons are ones that I've already alluded to. States have signed on to the New York Convention. It's one of the most universally adopted conventions and most successful conventions in international history, at least recent international history, because it facilitates an efficient, an expert, a neutral and objective, and an enforceable means of dispute resolution. And because it does so in ways that are substantially better than the alternative means that are available for international dispute resolution. And by facilitating this means of international dispute resolution, contracting states also facilitate international trade, international commerce, and international investment. And by doing that, they enable private parties to more reliably, more securely, more successfully engage in international trade and commerce for the benefit of all concerned. And so, for the same reasons that states have agreed to give effect to agreements to arbitrate and arbitral awards, states would be well advised to adopt bilateral arbitration treaties prescribing the same mechanisms of international dispute resolution as are adopted in many international commercial arbitration agreements of the traditional sense. And by encouraging more efficient, more expert, more objective and neutral, and more enforceable international dispute resolution, contracting states will also encourage international trade and commerce to the benefits of both their respective nationals and themselves. Now, that thesis I've obviously stated provocatively, but it immediately raises a number of potential objections, a number of buts, and with that I can turn most directly to the possible objections to the concept of a bilateral arbitration treaty. The first objection I've foreshadowed in a sense, and that is, why is it that states might want to enter into a bilateral arbitration treaty? And as I've explained, states at the end of the day would want to enter into a BAT for many of the same reasons that they have signed on to the New York Convention, on to the IICSL Convention, and agreed to international arbitration as a means for resolving international investment disputes, because international arbitration works better, it's more efficient, it's more expert, it's more enforceable, and it's more neutral than other forms of dispute resolution, and particularly forms of dispute resolution that involve recourse to national courts, especially in the commercial context, and I'm going to come back to that in a moment. The second major but that I think arises in many readers and many observers' minds is, well, what about the notion of party autonomy? What about the notion of consent? Isn't this that imposing arbitration on commercial parties? Isn't that a violation of basic principles of contractual freedom and party autonomy? And to that, I think, I again have already foreshadowed the answer. The answer is no. The BAT, as outlined, does not infringe on notions of party autonomy. The BAT provides a default solution, a solution that applies only when parties have not agreed, either expressly or implicitly, on other forms of dispute resolution. Nothing in the BAT precludes parties from agreeing to and enforcing a forum selection clause, an alternative arbitration provision, an expert determination clause, or anything else in their commercial agreements. Nothing stops parties from agreeing after a dispute has arisen to an alternative form of dispute resolution. the BAT provides, and only provides, a default mechanism, and in that sense can't be said to intrude upon the parties' contractual freedom, which remains exactly as it was, or upon the parties' autonomy, which they can exercise just as they otherwise would, to agree on whatever form of dispute resolution they choose to do. So a third but related to the concept of party autonomy is, yes, perhaps the BAT doesn't intrude upon the party's autonomy directly, but arbitration traditionally has rested on the principle of consent. Case after case, treatise after treatise confirms, acknowledges that arbitration is a creature of consent on the one hand, and that without consent, without the party's consent, one can't have an arbitration, one can't have an international arbitration. Now, there's a two-part answer to that, and that is, like the other buts, a serious issue that needs to be confronted directly and openly. The first part of the answer is, yes, it's correct. The concept of arbitration under a bilateral arbitration treaty dispenses with the notion of consent, at least to an extent. But it doesn't pretend to do otherwise. Just as in a bilateral investment treaty, arbitration is a creature of constructive consent, is essentially a legislatively prescribed means of dispute resolution. So, international arbitration under a bilateral arbitration treaty doesn't pretend to be a traditional arbitration agreement. Rather, it is, and it openly is, a legislatively prescribed means of dispute resolution. And it is a legislatively prescribed means of dispute resolution for the same reason that international arbitration is used in bilateral investment treaties. Because, to repeat what I said before, it's more efficient, it's more objective and neutral, it's more expert, and it's more enforceable. It is a better means, a better default means of resolving international disputes than the other available means, and in particular, resolution of disputes in national courts. And I promised once before, and I promise again, come on and look at that more specifically. But the absence of consent doesn't change the fact that that means of dispute resolution, international arbitration, is superior to and should be preferred to other forms of international dispute resolution, and therefore is the appropriate default means of international dispute resolution, at least for commercial or business disputes. Now, the second part of this answer is, in fact, to push back somewhat on the notion of consent. I said previously that this is a legislatively prescribed default solution, and that is true, but it's only true to a point. Recall that we're dealing with commercial parties. That's what the bilateral arbitration treaty, the BAT, addresses. And we're dealing with commercial parties who, for whatever reason, have either not included any dispute resolution provision in their contract, or have included one, but done so pathologically, done so such that it's not enforceable, it has a defect for whatever reason. And so the very specific question that I think one needs to ask them in considering issues of consent is, what would the parties' intentions, what would the commercial business people's expectations about dispute resolution be in those circumstances? Now, the truth of the matter is, and we all learned this in arbitration, International Arbitration 101, is that in many cases, parties who haven't included a provision in their contract, indeed in some cases when they have, haven't really thought about dispute resolution. They haven't really foreseen the awful possibility that disputes might arise. They're still too focused on having done the deal. They're too focused on their expectations of profits and smooth sailing to foresee what might happen in the event that disputes actually arise. But if you take a step back and think about what is it that commercial parties reasonably and sensibly would want, would expect in international dispute resolution. Wouldn't it be, isn't it, that their disputes would be resolved as efficiently as possible, as neutrally as possible, and fairly as possible, as expertly as possible, and as enforceably as possible? That is what their ideal expectations would be. That is what, if they had the choice, I would submit before disputes arise, they would choose. And that, in a sense, takes me to what I promised you a couple times, which is a comparison between international arbitration on the one hand and dispute resolution. Use my example of Singapore and Romania again, dispute resolution in national courts on the other hand. One of the fundamental difficulties of international dispute resolution in the commercial context is that if you rely on national courts, one party will always be in the other party's home courts. The Singaporean party will need to litigate in Romanian courts. The Romanian party will need to litigate in Singaporean courts. And with no disrespect to either country's courts, neither party is particularly comfortable litigating its disputes in its counterparty's home courts. Indeed, that's one of the reasons that commercial parties so prefer international arbitration as a means of dispute resolution. Equally, both parties will, in almost all cases, be litigating before courts of general jurisdiction, courts who hear a whole range of matters, ranging from domestic matters to tax matters, to criminal matters, to labor matters, and will not be particularly experienced in or expert in international commercial dispute resolution. While in contrast with international arbitration, the parties will be free to choose tribunals composed of arbitrators with expertise in the particular subject matter of their dispute, whether it's an insurance dispute, an M&A dispute, a construction dispute, or some other sort of dispute. The parties will be able to handpick arbitrators and tailor-make procedures designed for their dispute instead of being put into a one-size-fits-all set of procedures and one judge decides all set of decision makers in their counterparty's home court. And indeed, that's only the best part, if you will, of how national courts would resolve international commercial disputes. Because what one also has to reckon, again in my Singapore-Romanian example, is a whole set of jurisdictional objections on each side in both sets of national courts, set of forum nonconvenience disputes. Indeed, one has to reckon with the possibility of anti-suit injunctions and ultimately with the possibility of both sets of proceedings, the Romanian and the Singaporean, going forward to judgments, the judgments which won't be recognized because there's no treaty for the recognition of judgments between the two states in either of the parties' home states where their assets are located. And so at the end of the day, what that model, what the traditional model of dispute resolution, absent an arbitration agreement, produces is dispute resolution that isn't efficient because it almost always involves jurisdictional disputes that are quite substantial and because it almost always involves parallel proceedings, and that isn't particularly expert because it involves courts of general jurisdiction not tailored to particular disputes, and that isn't particularly objective or neutral because each party must litigate on its counterparty's home territory, and it certainly isn't enforceable or binding because the ultimate judgment won't be recognized. And in those circumstances, taking a step back from it and asking ourselves, what is it that international businesses would want as between those two models? I would suggest that the answer isn't the traditional model of dispute resolution, but rather is something rather like what the bilateral arbitration treaty would provide. Now, certainly, there's room for debate about that. Certainly, that is a form of implied consent that pushes the boundaries of consent, certainly in the traditional sense. But I think when one thinks thinks clearly and specifically about international businesses in this context, there's substantial force to that. And there's a final point that I think it's important to consider in the context of a bilateral arbitration treaty, which is that once the bilateral arbitration treaty prescribing a default means of dispute resolution has come into force, has been published to the business communities in the two contracting states, then the argument for consent, for actual real consent, becomes substantially more formidable. It becomes an argument then that the parties contracted against the background of the default mechanism. They were aware of it or on notice of it and chose not, as they're fully free to do, to change that form of dispute resolution. And in those circumstances, as I say, the argument for effective consent becomes even stronger. And indeed, one can imagine bilateral arbitration treaties providing in terms for constructive consent on the part of parties that choose not to contract out. I'm not sure that fundamentally changes the policy considerations at issue, but certainly in terms of traditional analysis, it would make the argument for consent even stronger. So let's turn and look at a fourth possible thought. We've talked a lot about some general objections to the concept of a bilateral arbitration treaty, but how exactly would an arbitration under a BAT work? Isn't the whole concept unduly speculative? Is there any realistic, practical way to implement it? And I think the answer there is really quite straightforward. As I mentioned, a BAT, a bilateral arbitration treaty, can readily incorporate the UNCITRAL rules, for example, or some other set of institutional rules. Many bilateral investment treaties do so, and work arbitrations function perfectly well under those provisions. Those rules, the UNCITRAL rules, give the arbitral tribunal the authority to choose the arbitral seat, for example. There's no need for the parties to do so. The UNCITRAL rules also provide a means for choosing and appointing authority. The PCA, the Permanent Court of Arbitration in The Hague, is perfectly capable of choosing and appointing authority in the event that parties are not able to agree on who the arbitrators should be, or indeed on the number of arbitrators. And so in those circumstances, there's no reason that an arbitration couldn't be conducted perfectly well under the UNCITRAL arbitration rules. Indeed, the UNCITRAL arbitration rules set forth a procedural framework for the arbitration that functions perfectly well in both international commercial and international investment arbitrations. And there's no reason that they wouldn't function equally well under a bilateral arbitration treaty model. And if one wants to take the analysis a step further, nothing would stop contracting states under a particular BAT from choosing a particular arbitral institution. They might, for whatever reason, not want to use the UNCITRAL arbitration rules. And for example, if they were states from the same geographic region or the same cultural background, they might wish to choose a particular regional arbitral institution, one in Europe, for example, one in Asia, one in Africa, or what have you. And nothing at all would in the basic model of a bilateral arbitration treaty would inhibit that. And as a consequence, I don't think there's really any serious question but what were contracting states to conclude a bilateral arbitration treaty. Arbitrations could quite readily be conducted under the procedures that treaty identified, whether it is the UNCITRAL rules or another set of institutional rules. A fifth or sixth possible objection to the concept of bilateral arbitration treaties is that it would require ordinary citizens to give up their rights of access to national courts, and that is in some fashion inappropriate or wrong. Indeed, in some countries there may well be suggestions that there are constitutional limitations on requiring parties to give up, without having explicitly consented, give up their access to national courts. And again, a two-part answer to that, and when I'm done with that, I'm pretty close to the conclusion of this inaugural talk. The first part of the answer is that it's important to go back to the parameters of the bilateral arbitration treaty and to focus on the fact that what we're talking about here again is merchants and businesses. We're not talking about consumers. We're not talking about husbands and wives in domestic disputes. We're not talking about employees and labor disputes. We're talking about a specific category of commercial disputes involving businesses, and indeed one could imagine states requiring that the concept of business be defined more specifically, requiring businesses of a certain size so that the mom and pop grocery store on the corner or newsstand might not be covered if that was thought undesirable. So initially, when one talks about who it is that's being supposedly denied access to justice, it's important to focus on the category of people who would fall within the bilateral arbitration treaty. And I should also say at this point that the bilateral arbitration treaty could, and to some extent following the New York Convention, probably would define certain subject matters as opposed to parties, certain subject matters as non-arbitrable. Matters relating to criminal law, matters relating to bankruptcy, for example, could be defined, should that be desired by the contracting states, to be non-arbitrable under the terms of the BAT. A similar approach has been taken, of course, in Article 5.2 of the New York Convention, and there are good and sufficient reasons that it could be adopted in the BAT context. But let's turn then to the second part of this objection, which again is a serious one that needs to be considered carefully. Even if we're only talking about businesses, even reasonably substantial businesses, aren't they being denied access to national courts in contravention of at least important public policies and in some cases constitutional protections? And it is certainly, and doing so without having consented to do so, which raises particular objections. Now, to some extent, I've addressed these questions already in the context of the asserted absence of consent under a bilateral arbitration treaty, but I want to come back and focus specifically on this point in the context of an alleged denial of access to justice. And it is certainly true that in a purely domestic context, legislatively requiring parties to have recourse to arbitration, private arbitration, so to speak, might raise those kinds of concerns about access to public justice. If a legislative body decided that that was the appropriate means of dispute resolution, perhaps those concerns are less pointed, but they're nonetheless there. There are guarantees of access to public courts in public proceedings as part of any citizen's civil rights. But let's think about those guarantees, particularly in the context of international transactions. Because in the context of international transactions, one's not, of course, talking about access to one country's courts. One's talking inevitably, as we've already seen, about access to two countries' courts, at least two countries' courts. And as I've outlined already, I think there's a very powerful argument that access to justice, access to the other party's home courts in inefficient and non-objective proceedings that will produce unenforceable judgments isn't, at the end of the day, access to justice. And that where one really gets justice is in the neutral, efficient, expert, and enforceable dispute resolution mechanism that already exists in international commercial arbitration and investment arbitration, that's already given effect by the New York Convention. And that what the existing model for international dispute resolution really provides isn't access to justice, but a denial of justice. And that the real way to realize, the real way to give effect to guarantees for access to justice is precisely through a bilateral arbitration treaty. And indeed, it is for those reasons that the parties' real intentions, if they haven't agreed otherwise, are on a mechanism, a neutral mechanism, an enforceable mechanism, like that provided by the bilateral arbitration treaty, rather than the prospect of duplicative, multiplicitous proceedings that end up with judgments from one party's home court that can't be enforced anywhere else. And so that leaves me with the final possible but, the final possible objection to the concept of a bilateral arbitration treaty. And that is, put really simply, fear of the unknown. Fear that is something different, something untraditional, unorthodox, and that, therefore, we ought to stay away from it. Well, exactly those same kinds of objections were raised to the New York Convention, regarded in its day as a revolutionary instrument which took decades to really gain force, gather momentum. Exactly that same objection was raised to bilateral investment treaties and the use of arbitration there. And again, in both cases, those objections have been overcome. Sometimes those objections have required significant changes to the basic procedural approach. But just because it's new, just because it's innovative, just because it's not what we've always done, isn't a reason not to pursue this. And so I'd like to close again by thanking Professor Rogers, thanking the PACE online Moot forum for the opportunity to talk with you today. It's a somewhat one-sided conversation, but I guess that's inevitable given the technology. I hope the talk has stimulated interest, if not in the proposal, at least in the subject of international dispute resolution. And I look forward to being able to log in and hear your next speaker. Thank you very much.
Many, many thanks to you, Gary, for the set of very fresh and innovative ideas you just presented. Actually, what I like about this platform is that it allows for some level of interaction. And if you have 1 or 2 minutes, I would love to be able to ask the audience if they have any questions. Given this version, the version that we're using for the online pre-Moot, they actually can raise their hand. Here they can't. So if you do have a question, if you can indicate your name in the chat box in the bottom right-hand corner, if you have a question or comment, we'll just see if we have any immediate thoughts, questions, or comments that come to mind. And then if you indicate your name, then we can unmute you and you can share. Okay, okay, I'm seeing a couple of names. So I guess let's do Sidhan. Okay, I'm butchering the name, I'm sure. So let me just unmute you so you can introduce yourself.
Hello?
Yes.
Yeah. Hi, my name is Siddhant Ramachandran. Hello?
Yes, we can hear you. Ask your question.
Yes, my question is this. All the advantages of international commercial arbitration that Professor Bond has cited in favor of his new innovative idea also exist through a consensual model. So what exactly is the new thing or new advantage which BATs would bring which lead to their adoption as opposed to normal consensual arbitration?
I'm not sure I heard the question exactly, but I may have. Vicky, shall I try to respond? Okay. If I understand it, the question is, what advantages specifically would a bilateral arbitration treaty provide beyond what already exists for international commercial arbitration? In its current form, and I think, the answer there is that if it were adopted, a BAT would require arbitration in a substantial category of cases where parties did not agree previously to an international commercial arbitration agreement. If parties' commercial contracts did not include an arbitration clause or a forum selection clause, and simply silent, the bilateral arbitration treaty would itself prescribe as a default means of dispute resolution international commercial arbitration. The treaty would provide the benefits that I've outlined, and one can debate how significant those benefits are and what their costs are, in circumstances where there was no pre-existing bilateral arbitration agreement. And in so doing would, I think, materially expand the scope of disputes, commercial disputes that would be subject to arbitration. I mean, indeed, that very advantage, I think, would be characterized by some critics as a potential disadvantage, precisely because the parties in that set of cases would be required to arbitrate disputes without having previously consented in the traditional form of a contractual arbitration agreement.
Okay, I think we have one additional question from Guillermo. Just 1 second. Let me get over to him. Guillermo, did you have a question?
Yes, it's regarding more about investment arbitration and how the states must address the problems of paying all the investors in arbitration, like in Argentina. It happens that Argentina didn't have enough money to pay investors, so they went to a series of agreements in order to pay them. I don't know if there is a trend in international investment arbitration to try to pay them, no matter how, on different policies. And I want to hear just some comments here.
Yeah, the question, in a sense, goes a little bit beyond the concept of a BAT, a bilateral arbitration treaty. So perhaps let me say a word first about how it might apply to the concept of BATs in response. Note that unlike a bilateral investment treaty, the parties to arbitration under a BAT would, for the most part, be private commercial parties. They'd be businesses, a business incorporated in Romania, another business incorporated in Singapore, private, not state-owned. And those businesses would, in any event, in the case of a dispute, be required to fund litigation in their respective national courts, on the one hand, or potentially, as I've already outlined, parallel litigation in 2 or more national courts. And the basic objective of this proposal, the concept of the BAT, would be to reduce those costs, the cost both of parallel litigations on the one hand and of unenforceable decisions, unenforceable judgments on the other hand, in which case all the money that's been spent has been wasted since the judgment can't be enforced. I should also say that, in a sense, this is a little, it's a happy fortuity, but one can also readily imagine the use of technology, like what we're using right now, as a way to reduce costs in these bilateral arbitration treaty disputes. Rather than having to go to the home courts of one's counterparty, one could resolve the dispute in a neutral arbitral forum assisted by technology like this as a means of reducing costs. As to the difficulties of paying for counsel in traditional investment disputes, it's obviously an issue that arises on both sides. Investors as well as host states can have financial difficulties. It's an issue that arises not just in the bilateral investment treaty context, but frankly, in any context. Every domestic court system has to grapple with those challenges. And again, I think the technology that this program represents or is using provides some innovative and creative possibilities for trying to address those problems.
Great. We have one final question from Akshay.
Professor Bond, I had a question with respect to the acceptability of this particular form of resolution, dispute resolution. Considering the criticism that investment arbitration has gotten recently and the pedestal on which standard of access to courts is put by a lot of countries, do you think states would be acceptable to signing such badge with each other? And how do you see this going through in the future?
I'm really sorry, but it was very difficult. Vicky,
Yes,
did you?
No, please repeat it. I thought you might have gotten it, but if you didn't either, okay, please repeat it.
If you can stay close to the mic.
Yes, go closer to your microphone.
Considering the criticism that investment arbitration has been getting recently and the pedestal that traditional litigation and access to courts is put on, how do you think states would approach bad as such? Do you think it would be as acceptable as investment arbitration is these days?
Okay, the quality. I think I have an idea of what the question was, and if I understand it, the observation is there has been a fair amount of criticism of investor-state arbitration in recent decades, and with similar objections be raised to bilateral arbitration treaties. And I think that is a good point and an important observation. I would note, however, that firstly, notwithstanding the criticisms of investor-state arbitration, it remains the least bad means for dispute resolution. A few states, but only a few states, have concluded that bilateral investment treaties don't offer an acceptable means of dispute resolution. Many states have remained parties to their BITs. Other states have sought to renegotiate BITs with alternative procedural mechanisms aimed at addressing criticisms which have been made of arbitration in the investor-state context. And in a sense, that's a healthy development. It goes back to some of the points that I made at the beginning of my talk. Arbitration as a means of dispute resolution in the investor-state context had its roots was in a sense borrowed from commercial arbitration, and it's not unusual, and it's entirely normal and appropriate that form of dispute resolution be then tailored to the investment context. Indeed, that's consistent with the basic promises of arbitration as a flexible means of dispute resolution tailored to each particular type of dispute. Secondly, though, I should say, and the same sort of tailoring as I mentioned, can and should go on in the context of bilateral arbitration treaties. The procedures in particular cases ought to be tailored by the contracting states to a particular treaty based on their mutual expectations, their mutual legal and cultural backgrounds, their languages, and so forth. Secondly, and I think this is important, in a sense, bilateral investment treaties, investor-state disputes deal with some of the hardest disputes to resolve that there are. They deal with challenges by a foreign investor to exercises of sovereignty by a host state. And those raise a host of delicate and sensitive issues. Those issues arise whether you're in domestic courts with constitutional challenges to state action, but they arise in particular in the investor-state context. And so it is understandable that criticisms and controversy have arisen. As I say, efforts have been made, continue to be made, to address those controversies and criticisms. But and this is the important bit, so to speak, no pun intended, in the context of that. those disputes, commercial disputes, don't raise the same types of sovereign sensitivities that investor-state disputes arise. They rather involve commercial disputes, typically not raising high issues of state sovereignty or difficult questions of international law, but rather application of contractual standards and commercial law, which ought in principle to be capable of resolution much more readily. And I hope that was the question that I was asked. In any event, I think it is an important aspect of the proposal, and thanks again for raising it.
Okay, with that said, I'd like to thank you again very much for the presentation, and I will bring this session to a close. Have a great afternoon and rest of the week. Thank you. Thank you very much.